CNA District Court for County of Washington, State of Michigan, Judge Simpson. All those having business before the court draw near. The Honorable Judge Simpson presides.
You may be seated.
I'm sorry. So sorry.
Court does call the cases of the people of the state of Michigan versus Willow et al. Counsel, state your appearance. Starting.
Ryan Baron, P8665 on behalf of Mr. Anatoli.
Warrants on behalf of Mr. McKee Shapiro.
John Minnick on behalf of Avi Taknafram, who's present via Zoom.
And is he?
Yes, he is in Zoom, Your Honor.
He's in Zoom. Mr. Dr. Fromm, could you please turn on your camera, sir? Oh, there he is. All right. Thank you.
Good morning, Your Honor. May it please the most honorable court. My name is Amir Mackley, representing Ms. Samantha Lewis, who's present in court this morning. Thank you, Judge.
My name is Stacy McNulty, and I'm representing Mr. Oliver Kosler.
Good morning, Your Honor. Mark Hyder, appearing on behalf of Assad Sadaki, P35-143.
Yes, that leaves me, Your Honor. Jamil Kuja, appearing on behalf of Michael Miller.
All right.
Good morning, Your Honor. Rhonda Riddell on behalf of the people, P68287.
All right. Thank you.
Today,
Yes.
any concept for a ruling in this matter. However, at this time, Your Honor, people move to dismiss these cases.
No objection, Your Honor. We'd like to thank this court. Thank you.
No objection.
No objection.
No objection. Thank you.
No objection, Your Honor.
No objection.
All right. Given the motion of the people, all of these cases are dismissed. That is without prejudice. Thank you, folks. Thank you, counsel. Court stands in recess.
Thank you, Judge.
Want to go to you again?
District Court for County of Washington, State of Michigan. I'm back in session. The Honorable Judge Simpson.
You may be seated. Court does call the case of the people versus Travis Oliver.
Alexis on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Oliver, who stands to my right. Please state your name for the record, sir.
Travis Oliver. Thank you. All right, what do we do?
Thank you, Your Honor. There is a resolution in this matter to which Mr. Oliver will be pleading no contest as charged under a prosecutor's deferred.
The next part, Your Honor.
Prosecutor's deferred. Yeah, have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
State your name.
Travis Oliver.
Sir, it is this court's understanding that you are going to be pleading no contest to the charge of malicious destruction of personal property less than $200. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
You understand that the fine could be increased to 3 times the value of the property destroyed or otherwise injured. If that's greater than $500, that would become the maximum fine.
Yes.
Do you understand what a no contest plea is?
Yes.
2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea, counsel.
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
You understand that with pleading no contest, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case 25-1258. Any objection to the court having reviewed that report?
None from the people, Your Honor.
No, Your Honor.
Based upon a review of that report and also the court having heard the testimony in this case, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
Second at 1 p.m.
June 2nd, 2025, 1 p.m. Defendant's bond with its condition.
Yes, sir.
Stop at probation. You're on your left-hand side, stop in there, get the process started. All right.
Okay, thank you.
All right. Thank you.
Your Honor.
Thank you, Your Honor. Thanks.
That's all Miss Pate had?
It is till 1 or noon.
Oh, so you'll be back. Okay.
Sam.
Sam? Hello, pleasure meeting you. Where are you in school? Of course, Stanton recess.
What was that? Sorry.
Are you in school?
Yeah, Michigan State.
Why are these Spartans? I just met another Spartan.
Fourteen A District Court for County of Washington, State of Michigan is now back in session.
You may be seated. Yes, ma'am. Court does call the case of the people versus Stephen Grisby.
Alexander on behalf of the people, Your Honor. Is Mr. Burns. Do you want to go check the hallway?
Or you could just sit there, either way.
I just saw him.
He was just back there.
Maybe he went to bed.
Like this happens every time a case gets called first.
Yes.
So, here with and on, Sam Bernstein with and on behalf of Mr. Grisby, who's present with me.
Your name, sir.
Stephen Grisbeck.
All right. Go ahead.
Here for sentencing, Your Honor. We were here last week when everyone very graciously and patiently listened to me ask for possible sentence where Mr. Grisby would do the accountable choices program in jail with release on a tether to probation afterwards. And I appreciate Ms. Pilara and Ms. Senda for listening to me and Your Honor, of course. Mr. Grisby has been trying to get into that program since he got into jail, but he's been really pushing the last 2 weeks with kites and so forth. And they visited him last week and told him that there's 52 court-ordered people in line before him to get into the course, making it the most popular course in Washtenaw County on any given night. So I'm not exactly sure how that's going to play out for him, given how long it would take him to get in there. He'd be doing a significant amount of time before completion. One of the things I've been talking about that he's concerned about is his Section 8 voucher. He's worked very hard to get it, and he's about a month away from potentially losing it. Maybe a month and a half that he worked very hard to get, and he does have a job for the meantime, but we don't know how long with heating and cooling. That it's been a pretty good job for him. So he's gotten some strides going in his personal life that he stands to lose. And I think maybe he could have held it together if he thinks accountable choices would start in the short term, but I just don't know that it is. So I guess we are asking the court to consider maybe like a release to drug treatment in the interim. To get,
How long is the program, the in-jail program?
I think it's 13 weeks, Your Honor.
Okay. Did they, did they tell you, Mr. Grisby, or 52 ahead of you?
Yes, because I wrote a kite and they came back Thursday night and told me that there was 52 people ahead of me. That's with being court ordered.
Got it.
So there's 52 people ahead of me.
So those were 52 that had not started it yet.
I had not started it yet.
Okay. Well, I guess what I'd probably do is order this. I will, if we can find an alternative program with him out that would work for him, then I might consider release.
Your Honor, I can tell you that the program, the in-jail program is offered out. And in my recommendation, I was asking the court to have him complete the first phase in and then continue the full programming out. So that is how.
That's how it's structured. But I guess my question is it gonna take him, does he have to wait through 52 people to do that? And
On the
then,
outside, no.
pardon?
On the outside, no.
Right,
It's a
but
52-week program on the outside.
gotcha. But you want him to do the first phase of the DV program in jail, but he won't at best get to that. I mean, I don't know how many people are in the class, but he won't get to that at least for 13 weeks, probably much longer.
If the court is considering to release him so he can get started with that program on the outside, I would ask that he definitely have that GPS monitor on, so he can do that.
Let's do this. So, Mr. Wilson, did you verify that it's 52 ahead of him?
I have not verified, Your Honor. Mr. Grisby just told me. I'm happy to, I can email Mr. Henderson, who runs the program, or Lieutenant Arnett. Get like a
Here's
better.
what I'll do. I'll order what's here. I need it then checked as to how long it's anticipated before he would get in.
Yes.
And then I'll consider changing the program so that maybe he can complete part of that outside, or complete it outside as opposed to in.
That makes sense. I appreciate that, Your Honor, and I'll send some emails right after court.
All right. Anything else you want to say before I impose that?
No, Your Honor, I don't know if Mr. Grisby had a couple of things he wanted to say.
I just would like to say, Your Honor, I want to take accountability for my actions, and I apologize to the courts for going through this. And I just received my Section 8 housing voucher back in November, and I just got it. And if I do any more than like a month in jail, I will lose my Section 8. And I'm just asking that the courts, if I could do this class, and with one, if I won't make no mistakes. If I do make a mistake, I have to come back and do the complete jail sentence. I'm asking for one chance. I can't show you that chance if I'm locked up, Your Honor. And I've gotten sober back in October. I've been doing these classes prior to me coming into jail. So I had been sober prior to coming to jail. And I would like to show the courts that I can not get in any more trouble, and that if I complete this class, that it'll make me an even better person for today. I want to show the courts that I can do this.
All right. It's a sentence of the court, place you on 24 months probationary term. You're to pay $555 fines and costs, 720 probation oversight fees. I'm going to make that due and payable 45 days after release.
Those emails out.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the in-jail DV program, phase 1, and then remainder of the program, phase 2, after release. That's what I'll order at this time. And again, I would potentially change that if necessary, once we can take a closer look at when he can get in. Continue outpatient substance abuse treatment. Follow all treatment recommendations with status reports to probation. No contact with Samantha Smith, directly or indirectly. You're not to go to the residence or employment of Samantha Smith. You're not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to report to probation as requested by probation, including any home visits. Begin and maintain employment with verification to probation. You are to comply with any circuit court orders. I'll set a review hearing that's to be held July 7, 2025, 1 p.m. I will order 365 days in jail, credit 40 days served. Defendant to remain in custody until completion of the in-jail Dawn Farm program, or not Dawn Farm, DV program. And then the balance will be suspended with placement on a GPS tether prior to release. All right.
Thank you, Your Honor.
All right, thank you. Can you grab a phone off of that? Court does call the case of the people versus, is it Cyan Taylor?
Alexis on behalf of the people, Your Honor.
Good afternoon. Assistant Public Defender Lauren Kearney on behalf of Ms. Taylor. Ms. Taylor, please state your name for the record.
Cyan Taylor.
Your Honor, we are here for a pre-trial. I'd first ask to address bond, please.
You can go ahead.
Miss Taylor is being held on a $25,000, 10% bond. She failed to appear at a final settlement conference. I am asking that the court consider reducing her bond to a personal bond. Since then, her life circumstances have changed. She's now in a more stable position, I should say. She, at that time, was essentially homeless. She's kind of bouncing around. Now she's staying with her parents, or her family. Her mother is here in the courtroom. She also, at that time, wasn't working. She now has a job at Home Watch as a nurse's aide. She spoke to her mom, who spoke to that, and she will be able to return to that job if released. At final settlement conference, the people were unable to proceed. However, because she was there or not there, the warrant was issued. I don't know if circumstances have changed with the complaining witness at this point, but our intention is to set up for final settlement conference again, depending on the bond, I suppose. But I am asking the court consider changing the bond. She's been in custody now for over a week. How many days?
A week and 3 days.
11 days now.
That she's been in.
Yes.
Yeah. All right. Well, how did she come into custody?
I was at the gas station and they said they recognized me, that I had a warrant.
Well, I guess my question is, she missed the court date. Why didn't she come in at some point? Because that was back in October of last year.
Did you have a phone at that
No, not on, no. And also mail was going everywhere else. So it was hard keeping track of everything.
Yeah. I don't think, Your Honor, I think she should have gotten back in touch with us. She did mention to me just now that her, because she didn't have a stable housing situation, she wasn't getting mail and didn't have a phone. at that time, but now she does have, like I said, stable housing situation, is able to be contacted, about her case.
Any response from the people?
Your Honor, I just have concerns given that this was a failed to appear last year in October and there was no contact with the defendant until she was picked up by police. I'm sure the dates are given, and I'm sure the court is, those dates are given at these hearings. She would have had notice of the date, so I have concerns that she didn't show up until recently.
Well, how do I know you'll come back if I let you out?
I will. I don't want to
Well,
be
you told me it last time.
correct. I don't want to be here. I want to do better, and I'm not going to waste the court's time anymore. I just want to get back to my job. And I don't know. This was the biggest wake up call I needed, I swear.
Set jury final settlement conference for June 9th, 2025 at 9 a.m. Set jury selection for June 9th or June 6th is my jury final settlement conference, correct?
Correct.
So the first date is June 6th, 2025, 9 a.m. Jury selection, June 9th, 2025, 8:30. Both of those proceedings are in-person proceedings. I'll release the defendant on a personal recognizance $25,000 bond. She needs to have a GPS tether for location tracking prior to release. Thank you. Court calls case, People versus Artist Valentine Lewis.
Alexis on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perny on
Ma'am,
behalf.
did you understand that, what I did?
Yeah, she's gonna be on a tether at my house, right?
Right, but she may not get out right away. They've got to get her over, put a tether on her before she would then be released.
And can I say one thing real quick?
Sure.
I'm not making any excuses for her whatsoever, you know, and she's done like a lot of mess in the last, but, last Monday when she came to court, she had a full schedule starting for Tuesday. So I called her job and I let them know the circumstances. And they said that they'll, you know, if she gets out on the 5th, that we'll get back a hold of us. And
Okay,
hopefully she can keep her job.
all right. So hopefully they can get her out, get her over tethered, and she'd be out.
Do you know what time that would?
I'm not in charge of that. I don't know.
I'll find out.
Okay,
Thank you, Your Honor.
thank you. I'm sorry, Mr. Valentine, go ahead.
On behalf of Mr. Valentine Artist, Mr. Valentine Artist, please state your name for the record.
Artist Leroy Valentine Lewis.
Oh, I'm sorry, I totally butchered your name.
Yeah.
Your Honor, we're here for a show cause. Mr. Valentine owes $300 on a domestic violence case. He has been in custody for some time.
What does he owe?
Yeah, the $300 is a weird number. You did the time on.
No, it's not really, but go ahead. I don't know.
Well, it's usually if there's the case, they're much higher than $300. He did do 10 months on this case.
Well, hold on. When I issued the warrant for $75 cash. And then his bond now is 1,010%.
Yes, I saw that in JS.
There's $75 in institution, it's the 125 statements plus $100 in warrants fee and show costs.
Yeah, that's right. The real issue. So he's got the statutory $125 fee. He's got warrant fees which total $100, so that brings it to $225. But, and then $75 restitution.
I see.
When I bench warranted him back in September of 2020, I only set his bond at $75 cash because I wanted the restitution paid.
Yeah. Well, he was being held on other stuff. That has all been resolved. This is now the only thing that's holding him in Washington County Jail. So I would ask this court to order him to pay the $75 when he's
Already
released.
did that. That didn't seem to work.
When he's really, well, I will say at the time he did do 10 months, right? And he's been in here, how much time have you been in now?
2 weeks.
Okay. So, you know, I don't know if you're gonna work when you get out, but order him to pay that and really, and give him a personal bond. That's my request. I'm sorry, I'm just.
Does he have anybody that can pay the 75? Because realistically, that's what I want.
Yeah.
Because that's restitution. So if he can get somebody to pay the 75, the 125 is just there, but I'd release him.
He says he can pay the 75. You can have someone come up here and pay it as your bond.
75?
Yeah.
Not at this moment. So, I mean, if you want me to do some time on it, I could do some time on it because I got a parole hold.
No. I can't have you do time
On
in lieu of restitution.
Well, all right. It's kind of complicated because I got a parole hold right now for Arizona. So when I leave here, I got to go out there to finish my time out there. So I got 5 months parole left out there. So I got to finish my parole out there.
Okay, so here's what I'm asking. Is there anybody that can pay the $75 for you?
Right now, no.
At any point?
At any point, yeah. But not right now, not at this moment, though.
Define moment.
Like, when do you think you could get it paid?
As soon as I get out of here, shoot.
Yeah, but when you get out of here, you got to go to Arizona.
Yeah.
And then we're going to be right back in this boat because the 75 won't get paid.
Well,
The victim's been waiting for 5 years.
Yeah. Shit. I mean, when I get out, I'll be able to pay it when I get out. You know what I'm saying? I can't pay it right now. You feel me? Like, I gotta go take care of that, and then I'll be able to pay it. I don't even live out here, to be honest. So when I get out, I'm going back to Arizona, finish my parole, and I'll be able to pay it somehow. I ain't been out here in like 6 years, 7 years. Like, I don't even live out here.
Well, Your Honor, are you gonna be in custody in Arizona? Or you just,
Yeah, because I just did 3 years in prison, so I gotta finish like 5 more months.
Well,
but I'm gonna be able to pay it at some time, though.
Yeah.
Like, I'm not gonna pay it. I was incarcerated. I've been incarcerated in prison for 3 years, so I haven't been able to catch up on things. You know what I'm saying?
Yeah.
Yeah, like I just got out last August, so.
Well, given all that, Your Honor.
Anybody he can call to get $75? That's all I'm looking for in this case.
Yeah.
I mean, the 300, the other part of that, I mean, I'll waive the $100, the other part of that. Because I get where he says that he's been in, but the statutory fee will just sit there. I just need the restitution paid.
Any family members, I think?
Yeah. I can get it paid.
All right, here's what I'm gonna do. You have him make some calls, do something, see if we can get the 75 paid. I'll adjourn it out 1 week to May 12th, 2025, 1 p.m.
Would Your Honor consider changing it to 75? So then if he pays it in between now and.
Well,
Ally Zend on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Arnold, who should be present via Zoom. Sir, can you please unmute, turn on your camera and state your name for the court?
I don't know that I have anybody.
There's people in the waiting room.
There is?
Yeah.
You want to let him in? And I think we have it. Court does call the case of People versus Deontay Arnold.
Assistant Public Defender Natalie Pate with and on, hopefully with, but on behalf of Mr. Arnold, who should be present via Zoom. Sir, can you please unmute, turn on your camera and state your name for the court?
Hi, Deontay Arnold.
All right, thank you.
Thank you. Thank you, Your Honor. I have discussed this case with Mr. Arnold as well as the people. We're respectfully requesting a very brief adjournment to receive and review the media discovery.
And Your Honor, we do have a media notice in the file. It just hasn't been added to a discovery package, so it should only take like a week at most.
So a week to get it over?
At most.
Okay, so why don't you give me at least 2 weeks now?
May 19th at 1 p.m.
Adjourn the matter to May 19th, 2025, 9 a.m. or 1 p.m. Is that what you said?
Yes.
Yep, 1 p.m. Bond with its conditions will continue.
Thank
All
you,
right.
Your Honor.
Thank you, Mr. Arnold.
Thank you, sir.
Thank you.
Court calls case People versus Alexis Berry.
Alexis on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Alexis Berry. Please state your name for the record.
Alexis Berry.
All right.
Your Honor, maybe we should approach.
You may. Go ahead. What are we doing on this case?
Thank you. Oh, sorry, go ahead.
Your Honor, at this time, the people will be asking that the no contact order be put back into place on this case for the reasons stated at the bench.
And Your Honor, I have discussed that with my client and we do not have any objection to that being reinstated.
What I'll do in this case is I will delete the no non-consensual contact that the court added and reinstate or add the no contact provision.
Thank you.
And Your Honor, as to the pretrial, the people have extended an offer in the matter of pleading no contest as charged under a prosecutor's deferred. I have had a preliminary discussion with my client regarding that offer. I do need to have one final discussion with her before she chooses whether or not to accept it. I would request a very brief adjournment.
All right.
And Your Honor,
Go ahead.
sorry, Your Honor, the offer was to plead as no contest as charged under 4A.
Under 4A. All right.
Sorry, I misspoke. I think I just said a deferred. That was correct.
Okay, I'll adjourn this to May 19, 2025, 1 p.m. Bond will continue with the conditions as I've indicated. All right, thank you.
Thank you, Your Honor. Thank you.
Court does call the case People versus Alexis Naveen.
Alexis on behalf of the people, Your Honor.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Naveen. Ms. Naveen, please state your name for the record.
Alexis Naveen.
All right, what are we doing?
Your Honor, we have come to a resolution. Ms. Naveen is going to be pleading as charged, and this case will be transferred to the Veterans Treatment Court.
Here, correct?
Correct, yes, yes.
Okay. So she'll have to do the sentencing here initially. All right, got it.
Yeah, that was my question. So the sentencing will be before Your Honor, and then
And then it, as part of that sentence, she would be supervised under the Veterans Court.
and I know we deal with this every time. It's confusing. Does the memorandum, is that done at sentencing or today?
You know, I don't know. And I thought, and again, I thought when we did in-county transfers, the
Mhm.
memorandum was not necessary. But is that, have I been,
Your Honor, it's changed now. They require a problem.
all of them?
Paul Graveline
That makes
emailed.
sense.
and
Go
ex-
ahead.
I'm sorry, Paul Graveline emailed and said, I need this filled out from Veterans Treatment Court. So
Okay.
I think his understanding is he needs it. I just didn't,
That's fine.
I just didn't know when.
I thought. Isn't it done at the time of sentencing? I thought, but
It might make sense because it's not ultimately transferred until you sentence.
until I sentence and transfer, correct?
Yeah,
But then if the transfer doesn't happen, it comes back to me. Right, so.
okay. Well, I will work with your staff to get this filled out prior to sentencing
She's
then.
right there. No, anyway, all right. All right, so it's gonna be a plea of,
Guilty to the domestic violence count.
It was no contest.
Well, did we talk about that?
I thought so. I thought that was the understanding.
Okay. If that's the case, Your Honor,
you want me just to, I can adjourn it a week?
if that's okay.
No,
the-
that's fine.
The reason being, Ms. Naveen, I'm sorry, I don't know if that was with the previous attorney, but I need to submit a police report. There's some steps I need to take if we want to do a no contest.
Oh, okay. Okay.
Okay, and I don't have a problem doing that if you don't have a problem coming back and seeing me in a week.
Not at all, Your Honor. May I appear via Zoom?
I should make her come in. I haven't seen her in person forever. All right, no, yes, you can appear via Zoom. All right, I'll adjourn this to May 12th, 2025, 1 p.m.
Thank you.
And you're doing well?
I'm doing okay, Your Honor, adjusting.
All right, real good. All right, thank you. We'll see you next week.
All right. Yes, Your Honor.
Court calls the case, People versus Bradley Burkeen. It's just one on.
Your vote.
I have three.
There's a felony for me.
Okay.
Alexis on behalf of the people, Your Honor.
She is not.
Teresa Claire on behalf of probation, Your Honor. Mr. Burkeen is scheduled on 2 cases before the court for violation of probation hearings. Given that he is in non-compliance status and not present today, probation is asking for a bench warrant in both cases.
And here. Which?
So the probation cases, Your Honor, is 0826.
And 102132. Gotcha. Both those matters, bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety on each case. Those warrants will issue immediately, as he also does have other warrants before. Court calls the case of the People versus Robert Jones.
Alexis on behalf of the people, Your Honor. Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Jones. Mr. Jones, please state your name for the record. You're muted, Mr. Jones.
Robert Jones.
Thank you.
Your Honor, we're here for sentencing. We have a sentence report and do not have any material changes, additions, or deletions. We did review the recommendation. We do ask that you adopt it.
Mr. Jones, anything you want to tell the court before I impose sentence?
No, sir.
All right. Sentence of the court, I'm going to place you on 24 months probationary term. You are to pay $655 fines and court costs, $720 probation oversight fees. When can you get that paid, sir?
I'll need a little time, Your Honor. Right now, I'm currently in treatment and I'm not working.
All right. So you're currently in treatment and not working. All right. What I'm
Yes.
going to indicate, there will be a payment plan as arranged by probation. All right. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a domestic violence program as directed by probation. You're to complete long-term residential treatment at Dawn Farm, including all aftercare, with status reports to probation. No contact with Doreen Schelling. You are not to go to the residence or employment of Doreen Schelling. You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You are to report to probation as directed by probation, including any home visits. You are to comply with all circuit court orders, if any. I'll set a review hearing July 7th, 2025 at 1 p.m. I'll order 365 days in jail. Credit 1, the balance is suspended. All right. Thank you. Thank you, sir.
Thank you.
Court calls the case, People versus Senita Payne.
Alexis on behalf of the people, Your Honor.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Payne, who is approaching.
Hello.
Please state your name.
My name is Senita Payne. I know, so cute.
Your Honor, today is the date and time set for sentencing. We did review the pre-sentence report and do not have any changes. We also did review the recommendation. We ask that you adopt it.
Ms. Payne, is there anything you'd like to tell the court before I impose sentence?
No, sir.
The sentence of the court, I'll place you on 18 months prosecutor deferred sentence. You're to pay $555 fines and court costs, $540 probation oversight fees. When can you pay that, ma'am?
Is it okay if you put me on a payment plan?
All right. Do you have anything today?
Yeah, I should have at least $25 to $30.
All right. I'll indicate pay $25 today, and then the balance is a payment plan as directed by probation. Okay. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a parenting class as directed by probation. Continue dual diagnosis programming. Yes, Naomi's Nest, including random alcohol drug screening or testing, excuse me, with status reports to probation. There's to be no contact with Stephen Robinson or Solomon Robinson except via telephone, text, or email. No assaulted, threatening, or intimidating behavior. You're to report to probation as requested by probation, including any home visits. You're to comply with all circuit court orders, if any. I'll set a review hearing. That's to be held July 7th, 2025, 1 p.m. I'll order 180 days in jail. That is suspended. All right. Thank you.
Thank you.
Court does call the case, People versus Kyle Smith Blue.
Alexis on behalf of the people, Your Honor.
Public Defender Natalie Pate with and on behalf of Mr. Smith Blue, who is present via Zoom. Sir, can you please unmute and state your name for the record?
It's Kyle Smith Blue.
Thank you, sir.
Thank you, Your Honor. Excuse me, today's the date and time set for sentencing. We have had the opportunity to review the PSIR. We have no material changes or corrections, and we respectfully request the court to adopt probation's recommendation.
All right, Mr. Smith Blue, anything you wish to tell the court before I impose sentence?
Oh, Your Honor.
Sentence of the court, place you on 9 months prosecutor deferred sentence. You're to pay $555 fines and court costs. We will apply the bond. You're also to pay $270 probation oversight fees. When can that be paid? Mr. Smith Blue, when can that be paid?
You're still muted, sir.
You're
I think.
muted.
Oh, sorry about that. That could be paid by next week, or what would be the balance after that? After the bond applied?
Well, if I apply the bond, that the whole 500 should go to that, shouldn't it? Or is it gonna be 450? That was a question.
Sorry.
No, it's okay.
That would be 450.
Okay, so 450. So you got 270 plus 50. I think that's 330, 320
Yeah, I can have that paid on the 15th.
on the 15th.
Correct.
All right. Pay that balance then by May 15th, 2025. Thank you. There
Where
should
would
be
that
no
ap-
use of alcohol. I'm sorry?
Where would that appear at for me to, where would I go on to pay it?
You can do one of two things. On the screen, you're on a phone, so you have to swipe over. There's a QR code that will, if you know how to use a QR code, that'll take you right to it.
Okay.
The place to pay it. Just make sure you have your case number, I believe, with you, and then it can get paid that way. Okay?
Gotcha.
All right. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete an anger management class as directed by probation. There's to be no contact with Erica Baldwin, directly or indirectly. No assaultive, threatening, or intimidating behavior. Maintain employment with proof to probation. Set a review hearing that will be held February 2nd, 2026 at 9 a.m. I will order 93 days in jail. Credit 1, the balance is suspended. Ready, sir? Thank you.
Thank you, Your Honor. Thank you, Mr. Smith-Blue.
Court does call the case of People versus Anatoli Zubritski. Zubritski, okay.
Alexis Naveen on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Zubritski, who should be present via Zoom. Sir, can you please unmute, turn on your camera, and state your name for the court?
He's not here.
No, that's not him on the camera, Your Honor. Your Honor, I do not have an explanation for his failure to appear. Quite frankly, we have spoke several times of anticipation of today's sentencing. He was provided with a Zoom link. I would respectfully request an adjournment for the record.
Your Honor, Teresa Claire on behalf of probation, given that he's not here and this is the stock case, probation will be forfeited.
Bench warrant will issue for defendant's failure to appear. Bond $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court does call the case People versus Jeremiah Driscoll.
Alexis on behalf of the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Driscoll, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Jeremiah D. Driscoll.
And Teresa Claire on behalf of probation. Your Honor, Mr. Driscoll is before the court for a review hearing. The victim is present and would like to address the court. She would like to ask that the no contact order and the no go to order be lifted. I know that she did request this from the court prior. However, the court would not consider it until Mr. Driscoll got engaged in DV programming. He is attending and compliant with that program and compliant with his payments and reporting to probation. The victim, Kanisha Pruitt, is present. Would the court like to hear from her?
Yes, absolutely. Hello.
Hi, Judge Simpson.
What's your name?
Anisha Pruitt.
All right. What would you like to tell?
We need it lifted, the restrictions. I actually get birth in 10 weeks.
Pardon?
I get birth in 10 weeks.
10 weeks?
10 weeks. And I would like for him to be present.
You want him there?
Yeah. I don't have nobody else. I'm at work right now.
Okay.
So.
Okay. Is this your first?
No, this is my second in 17 and a half years.
Second in 17 and a half years.
Correct.
So that's like a first.
Yeah, it's like the first.
Okay. All right. You know, boy or girl, or
It's a boy.
it's a boy.
Mm-hmm.
Hope he looks like you. No, I'm just kidding. I'm just messing with you, Mr. Driscoll. All right. Do people have any objection?
Your Honor, I'll leave it in the discretion of the court.
All right. What I'm gonna do, Mr. Driscoll, so that you understand, I'm gonna grant the request. You understand that, sir?
Yes, yes, Your Honor.
All right, so it's gonna be a no contact. I'm gonna delete that. I'm gonna add a provision of no non-consensual contact, meaning that if she doesn't want you around, then you gotta leave the area. You understand that, sir?
Yes, Your Honor.
All right, very good. All right, thank you, ma'am.
Thank you, Joseph.
All right. And good luck to you.
Thank you.
So I'm gonna do that, change that provision. I'm going to continue all terms as previously ordered and set his next review hearing for July 14th, 2025 at 1 p.m. Without objection.
Thank you, Your Honor.
All right, thank you.
Thank you, Mr. Driscoll. You're all
All
set.
right, thank you, Mr. Driscoll.
All right,
Congratulations to
thank
you,
you,
sir.
everybody. All right, thank you, everybody.
Court calls the case, People versus Eric Bragg.
Alexis on behalf of the people.
Claire, on behalf of probation, Your Honor, Mr. Bragg was scheduled before the court for a review hearing. He is fully compliant with the terms ordered by the court, and I waived his appearance. Probation's recommending the officer continue with the next review hearing being set August 4th, 2025 at 1 p.m.
Hearing no objection, so ordered. That it? Until when? And in the scheduling. Fine. Court's.
Session, the Honorable Judge J. Simpson preside.
May be seated. Court does call the case of the People versus Clark.
Alexis on behalf of the people, Your Honor.
Shane Clark.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Clark, who is now approaching the podium.
People's emergency motion. Go ahead. You may proceed.
Thank you, Your Honor. The people filed this motion. I believe the defendant was arraigned on May 1st and was given a personal cognizance bond. And this was against the people's request for a $25,000 cash surety with a GPS tether. People have serious concerns in this case for particularly the victim's safety, with nothing more than a PR bond in place. In this case, the victim was defendant in an argument. He called her a fat bitch and pulled out a knife. He was held the knife to her throat while yelling in her face, "If you interrupt me again, I'll snuff you and kill you right here." He was so close to her face while he was yelling this that spit was hitting her face. He said right before he left the car, he stated once to her that once he gets his disability check, he's going to buy a .22 caliber gun and shoot her in the head. She's in fear for her life and her mother's. She also received a text, which I believe for it to be read into its entirety, and it says, "You better for real stay out of my way. Don't text me unless I text you. You take my child's phone away again, I'll dismember your whole body to pieces. No cap. I'm overplaying with you. I will literally just kill you and get my life right. Free healthcare. My daughter's safe with your mom. Keep fucking playing. CUNT. I promise you don't know how real I am." And I have just extreme concerns given that he held a knife to her throat and is threatening on multiple occasions in this one case to kill her. And after the arraignment, the victim did send us a screenshot of a text, I believe from March 28th, which was before this case occurred, from the defendant, in which the message said, "Call the cops, I don't give a fuck, I'll murder your ass the day I get out." And that was before this case. So I have concerns given that she has finally reached out to police about this defendant's behavior, what could happen to her, given that he's out on a PR bond for this, in which he threatened her life twice. Oh, probably more than twice, I believe. 3 times.
Response.
Your Honor, I'll be requesting that the court maintain the PR bond with GPS tether. Mr. Clark is currently on a GPS tether. It was addressed that day that one issue, as noted in the prosecution's bond motion, was a concern about a cell phone. Mr. Clark does have a cell phone, which he is using now for his
with his GPS tether that's currently on his ankle. The concern was a lack of data, not him not having that device. He now has data on that cell phone. He received that, he had until Monday today, the 5th, to obtain that tether device. However, he did so within 24 hours. He was released from jail on May 1st, 2025 at 3:57 p.m. I received a call from Mr. Washington, one of the tether agents from Community Corrections at 1:22. So within that small time frame, he was able to obtain data for his cell phone and go to Community Corrections to get a tether. Mr. Clark has also been in contact with social workers, one of whom drove him here today, who are assisting him greatly in obtaining housing, which he is now on a list for those who are chronically unhoused, and hopefully should be able to obtain housing soon, and to be put on a second list as housing vouchers are now being opened again. They've also been assisting him with other matters, such as his health. He is currently suffering from liver failure and has an appointment scheduled for May 9th and one for June 14th, which at that time, his social worker will be also assisting him in getting a hotel. As noted in the emergency bond order by the prosecution, Mr. Clark has successfully been dismissed from probation in the past, showing that he can follow court orders. He does have the money to pay for the tether. He does have transport for the court. And the complaining witness, while acknowledging that this is a serious case, does reside over 30 minutes away by driving. Mr. Clark does currently rely on his social worker for transportation. Again, those, as mentioned, anything mentioned by the prosecution, it's still allegations at this point. We are not here to litigate any of the allegations here today. We are here to address bond. I do not believe there is any change in circumstances that have occurred since his arraignment that I handled last week that would warrant any changing of his bond. He is currently on a GPS tether. The court can know where he is at all times. And I believe that this bond is sufficient to protect community safety.
Is the GPS just location tracking?
It's location tracking and includes an exclusion zone for the complaining witness's address. So he would not be able to get within a quarter mile of that address.
Where's the defendant residing at this point?
He is currently residing at a camp as he awaits housing.
At a camp?
Yes, he has a campsite that he resides at.
Where's the campsite?
By the Miller and Maple Park and Red, sir.
Well, just so that we're clear, this isn't by the Maple Miller Park and Ride?
Yes, sir.
So this isn't a commercial campsite. This is just a place that you have.
That I'm holding out until I can get help, sir.
Yes, so she is part of the Pathway Housing Program. I do have a letter from that social worker here if you'd like that, the honor. And Ms. Montaigne, the coordinator for that program, is in the courtroom at this time.
Pardon?
Ms. Montaigne, the coordinator for that program, is also in the courtroom. She is the one who helped Mr. Clark get arrived at the court today.
The only address I have is a South Line address. Is that a correct statement?
So, Your
How do the defendant and the alleged victim in this case, how do they know each other?
Honor, I believe they have been in an on and off relationship since January of 2018, and they have one child together, and that his previous DV from 2021 was with this same victim.
The child who resides with mom, is that?
With her mother,
Her mother.
the victim's mother.
It's the magistrate did order no contact with the victim's mother as well on the day of the arraignment.
I see that, but so does the victim reside with the mother also?
I believe so, because it says the child attends school in South Line as well, so I believe so.
How old's the child?
born in 2019.
6. 6. The defendant's not working.
The defendant is working on getting a disability at this time due to some of his medical concerns.
Okay, then how is he paying for the tether?
He does have some, he has shared with me, he does have some money for the tether.
Panhandle and pick up cans and do work for a lady that I know whenever she needs it. She hires me for yard work.
So how long have you been residing at the campsite that you set up?
Since last year, sir.
Are you the only one out there at that site?
Yes, sir.
Let me see, counsel in chambers, court standing.
Take a seat as you wait. Yeah, it's fine.
Back on in the record on the Clark matter. I've had an opportunity to speak with counsel in chambers, and what the court is going to do at this time, and Mr. Clark, I need you to understand what I'm going to do. I'm going to leave you on the DPS tether. I'm not going to increase any monetary bond that might incarcerate you. Okay, you understand that, sir?
Sure.
And then what I'm going to do is I'm going to, at this moment, increase the exclusion zone on your tether for all of South Lyon. Okay?
I understand.
And then, and I don't want it put on the record, but I'm also going to add a provision of no contact with the minor child. You understand that, sir?
Yes, sir.
All right. And then once the other part to this is that may change where I get more information regarding the victim, the alleged victim and her travels. And then I may be expanding that exclusion zone. Follow me?
Yes, sir.
All right. So that's what I'll do at this time. I think I'm going to need a new order. So I'll prepare a community corrections order with the exclusion zone is all of South Lyon. And then Ms. Zenda, if you could provide to the clerks the name, the minor child's name, and then we will be adding that to the no contact. So at this time, I guess theoretically the motion is granted. The exclusion zone will be extended to all of South Lyon, and I will add the child's name there. Anything further?
Nothing from the people, Your Honor.
Nothing from the defense, Your Honor.
All right. Thank you. Thank you, sir.